Good evening. My name is Randolph Meiklejohn. I'm a member of the Zoning Board of Appeals of the town of Brookline and the chair of this evening's meeting. Before we begin, I will confirm that all members and other persons anticipated to participate on the agenda are present and can hear me. Members, when I call your name, please respond in the affirmative. Stephen Brooks.
Present.
Wladimir Roger.
Present.
Staff, when I call your name, please respond in the affirmative. Cameron James.
Present.
And I'm aware there are representatives of town council's office here. I'm going to recognize them later in the case for which they're attending. All speakers should identify themselves by name prior to speaking. This meeting of the ZBA in open session is being conducted remotely and in a manner that is consistent with Chapter 2 of the Acts of 2025, which authorizes this body to meet entirely remotely so long as adequate alternative means of public access is provided. Adequate public access does not include public participation unless such participation is required by law. This meeting will feature public comment. For this meeting, the ZBA is convening by video conference via Zoom as posted on the town's calendar, which identifies how the public may access the meeting. Be advised that this meeting is being held and that some attendees may be participating by video conference. Accordingly, please be aware that others may be able to see you and take care not to screen share your computer. Anything that you broadcast may be captured by the recording. All supporting materials that have been provided to members of this body are available on the town website through a link in the agenda. The meeting will follow the agenda unless I note otherwise. Next, I will cover some ground rules that will permit clear and effective conduct of our business and help to ensure accurate meeting minutes. I will introduce each speaker on the agenda. After they conclude their remarks, I will invite each member by name to provide any comment, questions, or motions. Please hold yours until your name is called. Please also remember to mute your phone or computer when you are not speaking and to speak clearly and in a way that helps generate accurate minutes. Before responding, please wait until the floor is yielded to you and state your name before speaking. If members wish to engage in colloquy with other members, please do so through me. Finally, each vote taken in this meeting will be conducted by roll call. Finally, I'll explain how members of the public may speak in this meeting. If you wish to speak, you may either raise your hand using the Zoom feature or send a chat message to our host, Cameron. Cameron, I will ask you to help me look for raised hands and also to tell me about requests to speak that you receive via the chat. I will try to call on members of the public in the order in which their requests were received. When it is your turn to speak, I will call on you by name only. Please begin your remarks by confirming your name and stating your address. All right. Now, on the agenda this evening, we have 5 items. We're going to hear them in the order on the posted agenda. The first item is a continued hearing. The second and third items are new petitions for relief. And the fourth and fifth items both relate to property at 90 Ivy Street. For each case, the chair will introduce the case by number and address and identify the applicant or person who will speak on the applicant's behalf and ask if they will waive a reading of the public notice. The applicant will present the request for relief, and if the board requests it, the design of the project. And board members may ask questions of the applicant. Next, we will hear public comment. First, the chair will call on those members of the public wishing to speak in favor of the project, and then on those opposed. We will then hear the reports of the planning department and of the planning board and comments by the building department. Finally, the board will deliberate and give its decision. All right, to the first case on the agenda. The case number is 2025-000067. This is a continued hearing concerning property at 8 Fairway Road, where the project is to construct a rear 1-story addition with a basement extension. Just to summarize where we are, at an earlier meeting of the board in February, we had the applicant's presentation of the design And in response to questions about the design raised by members of the board, the applicant requested to continue the hearing to a later date. That's tonight. There are now updated design drawings received by the board and available to the public in the packet posted with this evening's agenda. I think what I'd like to do is to invite the applicant or their representative, and I understand the architect may be here, to briefly describe what has changed since we last met, and then to present the revised design and continue to the zoning argument, which we didn't quite get to in the first session. Let me ask, I see the property owner. Is there also is there an architect or advisor who will be making a presentation? Or Mr. Al-Gendi, would you like to start?
Yes, hi, my name is Sharif Al-Gendi. I am the owner of the property at 8 Fairway Road. I would like Mr. Al Martin, the architect. I would refer, to him to present the project. He is attending the meeting. I saw his name.
That's fine. Tell me his name again.
Al Martin.
Al Martin. All right. I'm going to recognize Al Martin. Mr. Martin, if you'd turn your camera on, if you don't mind, and then introduce yourself,
Yes.
and then you can tell us
good
what has
evening,
changed.
everyone. This is Al Martin, owner of Martin Designs Inc. I'm currently having issues with my camera here. Hoping that's understandable. We're working on a project at 8 Fairway Road in Brookline for Mr. Al-Gendi. So the project is a 3 seasons room, and we're seeking a relief under section 520, 5.22. What changed the project compared to the last submission is we have decreased the project size so it can abide by the 522, which is 20% of the allowed gross floor area. And we have so that we submitted drawings yesterday, and where the project changed has been clouded in red.
Yes, and can I just ask, as you get going, is there a date on these drawings? The ones in the packet?
It's on the bottom left.
Sir? Yeah, I can't see it actually on the screen because it's moving around. The date is 3/25/26. Is that right?
That's correct.
All right. Thank you. Please take us through the changes.
So I'd actually like to work on this plan that is showing, the FAR plan, which shows the FAR calculation. So this project has a lot size of 20,257 square feet. And, the floor area ratio is 0.225 of the total lot size. And we allowed 20% of that, which is 1,012 square feet allowed in the buildable area. So we have, decreased the 3 seasons room, which you can see here in an orange color. And we are proposing a room size of 1,010 square feet. We have removed the dressing room that was proposed on the previous drawings. That is no longer the case. All we're looking for,
the second floor?
Yes, that has been removed.
Right.
And we're looking to keep just the 3 seasons room to comply with section 522.
Can you update us about the basement and show us that part of the design?
So the basement has remained as is. The reason being that this is not going to be utilized as a basement. It'll be an unfinished space where the mechanicals for this room can be stored. This house is tricky because the way the existing grade is, the existing foundation sticks out about 36 inches or 3 feet above finished grade, and Massachusetts law, makes us have at least a 48-inch frost wall below grade. So even if we did a crawl space for this project, we would need to comply with the 48-inch frost wall, plus the other 3 feet that sticks up above grade. So all the floors can be flush with the first floor, which makes us have a 7'10" foundation. We're not doing a full height basement by choice. It's just how the grades is currently set at the existing dwelling, and we have to comply with Massachusetts minimum, which is 48 below grade. We have also added a bulkhead access to this unfinished area, because if there's ever a need for maintenance work, someone needs to get in there to perform maintenance work.
All right, thank you. Members of the board, any questions about the design? Steve?
I don't, thank you.
Wadner?
Yeah, I have a question. What would be in the basement, the new basement created? You referenced there's a bulkhead access.
It's on the right
For
hand
maintenance.
side, Mr. Ogie.
What is it?
It's on the right hand side. It's right where the red cloud is. If you could zoom in there.
Okay,
It's just a bulkhead. There's no roof over it. It's just literally a steel bulkhead that you just pull up and open. If you can go over to the right side or left side.
so are you saying there gonna be any
See,
equipment
right
in
there.
there?
Well, so the room needs mechanicals, right? HVAC and heating and cooling. So any of the piping can go under there. There's currently no space in the existing basement for the mechanicals for this project.
So are you saying that they're gonna be new equipment just for that room?
Yes, so the existing house, the existing mechanicals for the house cannot withstand the new addition. So new equipment such as baseboard heaters needs to be introduced for the new addition. And those mechanicals needs to be protected for weather purposes.
Okay, is it common to have a 3-season thing with 2-level height?
So the intent for this design here is for ventilation and lighting, which is very important for the client. So they wanted to propose a 2-story, open concept room like a cathedral. When you enter like a 2-story foyer in the house, you have those 2 stories as one piece. So this is the idea for the client, which is very important for them and their religion, where the sun really shines into this room, because their house right now doesn't have any lighting, and they like to spend some time inside this room during the summer and winter.
So are you saying that without having a level, a 2-story level, the room wouldn't be able to get as much sun? Is that correct?
That is correct in our view and the view of the client. The homeowner is present. He can verify that. But the sole purpose of this project that we've been working on for around 2 years and a half is for the client to have this extra lighting and glass around his backyard.
If can I explain this point?
Yes, Mr. Al-Kindi, just a second. Wadner, is there a reason you're focusing on the height
this-
of the sunroom addition?
Well, basically the reason why I haven't seen a structure, a sunroom with that height in terms of structure. So I'm trying to, I used to have one myself. It's very low compared to the house. And then if it's designed well, you get as much sun if you have a glass.
The
Surrounded
height
with
of the
glass, so
structure complies with all the codes.
I can explain it actually. Because I have a unique situation. On the southeast corner of my house, there will be a 40B project, and it will be more than 70 feet height. So my house right now, it gets sun in the winter, and it gets sun in the summer. When we did the shadow studies, our own shadow studies, I will lose the sun. The house will really be like a big dark shadow on the house all the time. But with the way this is designed, with all the glass, and that's why I want it high. I mean, I could have had it lower and add more, and add actually more rooms. But what I really cared about the most is to get light. Okay, I already have a couple of kids with vitamin D deficiency, but that's not the point for the board. But I mean, I do need the light. And this design gives me the light and give me the open space that I'm seeking. If I was in a different situation and this was like a sunny area and no building next to me, I would have had like what people usually do, like a 12-foot, like all glass, they call it sunroom. And I looked at that design, and I thought it was very expensive and it will not give me what I need. So I came up with this design that I haven't seen anywhere else. So yes, it is unique, but it will, like I do need it. And the way it's designed in the back, it respects all the setbacks. It fits nicely in the environment. I'm gonna have even a garden in there. I already talked to an arborist, and I will have like some irrigation system because I'm going to put trees inside it. So it's like a big indoor garden, because my yard, things will change for me after the other building comes up. So this for me is like, I don't want to move. So for me, that's a way kind of like to make up for what's going to happen, in the land next to me, in the property next to me. And a big indoor garden. And that's another reason I needed a big ceiling or a high ceiling, because I'm going to put like trees in there.
Thank you, Mr.
Thank
Algendi.
you.
Is that answered your question?
Yeah,
now?
that's right.
Okay, thank you. I've got just one question. This is it's back to the basement. Mr. Martin, you commented that there is no intention to use the basement as occupiable space. You may have seen in the zoning bylaw in 509(2)(n) a requirement that when we give a special permit for a building such as this, which has basement or attic space, in this case basement, which isn't proposed to be habitable, but could in the future be made habitable, for example, by the addition of windows, we need to set a condition on the permit addressing the extent to which this space could or could not be converted to habitable space into future. I just want to make sure you're aware of that. And are you? And is Mr. Algendi
Yes,
amenable to such a condition?
we're totally fine with the condition, Mr. Randolph.
All right, thank you. All right, I don't think we have any. That's it for questions from the board. We're going to turn to public comment. And Mr. Algendi, if you're the one sharing the drawings, I think you can take it down. Cameron, have we got members of the public present who would like to speak in favor of this project?
I do not see any hands raised.
Okay, how about anyone wanting to speak in opposition?
I do not see anything, no.
Okay, on we go. So let's hear the report of the planning department and the planning board.
Yep, so the planning board is supportive of the application. The board found that the proposal met the criteria for special permit under 509 design review and had no objections to the relief requested for the FAR. The planning board recommends approval for the site plan prepared by Stephen E. Stepinski, PLS, dated August 21st, 2025, and the architectural plans prepared by Timothy M. Sheehan, RA, dated March 25th, 2026, subject to the following conditions. 1, prior to the issuance of a building permit, the applicant shall electronically submit final floor plans and elevations stamped and signed by a registered architect and a final site plan stamped and signed by a registered engineer or land surveyor to the Director for Regulatory Planning or designee for review and approval. And 2, prior to the issuance of a building permit, the applicant shall electronically submit to the building commissioner for review and approval the floor plans, site plans, and elevations displaying the approval stamp for the Director of Regulatory Planning and evidence that the Board of Appeals decision has been obtained from the town clerk's office by the applicant or the representative and recorded at the Registry of Deeds.
And Cameron, are you conveying comments from the building department this evening?
Yes, I am. The building department has no objection to the requested relief and will work with the petitioner to ensure compliance with the zoning bylaw, board's decision, and applicable codes.
Thank you. Board members, just any questions from either of those town reports? Steve?
I have no questions. Thank you.
No? Wadner, you okay?
No, I don't have any questions.
All right, so we're going to deliberate now. Let me start on this one. This is, among other things, a design review case under 5092J, requires a special permit. And as I just mentioned, it also, the bylaw also asks us to set a condition about the whether the finishing of the basement space is allowed in the future. For both the addition under 522 and the provisions of 5092N, for both of those special permits, the project must comply with the community and environmental impact and design standards. Normally we see a statement by the applicant or the designer. I don't know if we have one here, but this is a fairly straightforward house addition. And I'm one of the members who's actually been on this site and available with its context. I don't see any concerns on the environment or neighborhood front. I want to thank the applicant for working through the square footage. I agree with the calculations arriving at a design which has a gross floor area of 1,010 feet, as the drawings show, which is under the maximum allowed. I would propose that we find that this special permit should include a condition that the basement space not be allowed to be converted to habitable space in the future, and also find that the conditions A through E under 905 for the grant of the 2 special permits, A through E, have been met. And with that, I would support with those conditions. Wadner.
I agree with you, Randolph. I seen the new proposed project is not substantially more detriment to the neighborhood, so I will support it.
All right, thank you, Steve.
I would support it as well. I appreciate the change. I appreciate the work. It looks like you've been at this for some time, and hopefully it'll be a beneficial project for you.
All right. There you have it. That's a unanimous grant of relief, subject to the conditions that have been read into the record. I want to thank the applicant and their representatives again for participating in the continued hearing and for working through the design questions. And I wish you success with the project.
Thank you very much.
Thank you very much. Thank you.
Moving to the second case. Let's see. Second case is number 2026- there's 5 zeros here, 000001. First case of the year somehow. This concerns property at 119 Hislop Road, if I'm saying that right, where the project is to construct 3 small additions to a single family dwelling. Who is here as the applicant or on the applicant's behalf?
I am, Mr. Chair.
Mr. Allen, nice to see you. Will you waive a reading of the public notice?
I will. Thank you very much.
Thank you. Please tell the board about your request for relief.
Sure. For the record, my name is Robert Allen. I have a law practice at 300 Washington Street in Brookline Village. I'm here representing Paul and Sandra Edgerly, and we have Mike McClung from Shope Reno Wharton, who was the architect on the project. And I actually say Hyslop, Randolph. So tomato, tomato.
Thank you. Well, you go back farther than me.
Yeah, I guess.
I'm
That
gonna-
doesn't mean I'm
gonna
right,
rely
but-
on you, Bobby.
That doesn't mean I'm right, but just a
All
little
right.
background. 119 Hyslop is located in an S25 zoning district, Fisher Hill Historic District, across from what is now being used as the Pierce School. Neighborhood comprised of other similarly sized large lots and larger homes. This was found historically significant in October of 2025. They issued a partial demo stay. The project consists really of 3 additions. On the northeast corner, to expand the kitchen on the first floor and add a bedroom above the kitchen on the second floor. At the rear, to add a powder room on the first floor and enlarge the staircase. And third, at the connection between the main house and the garage, to add a powder room and expand the mudroom a little bit. Michael's done a great job making sure that the addition fits in and is consistent with the existing architecture. And the rear addition and the garage, they're not really visible from the street. The planning board had very little comments on the project. Loved the way Michael made it fit right in and look like it's been there. The project requires a finding of no substantial detriment under MGL 48 Section 6 for pre-existing non-conforming FAR, which is currently 0.29, where the minimum of 0.2 is required. The proposed is 0.31. The result, basically, we're adding 1,200 square feet, and I understand it's a large house. It's 15,000 square foot house. Will go up to 16,200, but you know, it's got some quirks in it, and the Edgerlys are just trying to work out these quirks, and it's pretty consistent with other homes, very large homes in that neighborhood. So the total gross floor area with the addition again is 16,246. The other existing nonconformity is the rear yard setback, which is 46.4 feet, where 50 is required. No, I will say, I think the staff report says 17 feet, but that's actually to the pool cabana. So I'm not sure they got that correct on that. The setback to the house is 46.4. So I have Michael here. If you want him to give the presentation, Mr. Chair and members of the board, he's happy to do it.
Yeah, let's see about it. And thank you for the setback clarification. That was going to be one of my questions. I don't, except for wanting to understand the setbacks, I don't actually need to see the architectural drawings presented. I thought they were quite legible in the packet, but let me ask the other members. Wadner, what do you think?
I'm all set with that.
Okay, Steve?
I looked at them before, and I don't need to see them again. Thank you.
Okay, I would just like to see the site plan, and but Bobby, if you could talk us through the existing proposed, because I looked everywhere for that 17 feet, couldn't find it.
Yeah,
So now I know. Now I know why.
Mike, if you just introduce yourself, you just show the site plan and the setbacks.
Happily. So my name is Michael McClung. I'm a senior principal with the architectural firm Shope Reno Wharton, and we've done quite a few nice homes in Brookline. If I can hit the share button, hopefully
You're good.
that will work. Oh, perfect. Okay, great. So that's the house in question.
It's not on the
Oh,
screen.
we're not seeing it yet.
Oh, I think it will come up in a moment. Sometimes it just takes a moment.
There you go.
Is it coming into focus?
You're good.
Terrific. Okay, thanks,
Yeah,
guys.
let's have the site plan with the dimensions on it. I think
Yes,
is what
yes,
we
of course.
want.
Yep. And sometimes takes the site plan just a little minute to load up there. If you're seeing that.
And that looks pretty good.
Okay, so that 17-foot dimension that was maybe incorrectly used on the chart is this dimension here from the property line to an open, it's basically a freestanding porch, open pool cabana.
Which exists.
Which exists, right? That's an existing cabana. This 46.4 feet here is from the property line to the existing corner of the garage. And we're not increasing the building towards the rear setback anywhere. So all of that is existing to remain.
So just give it to us as numbers. What are there set? Is any of the new construction setback less than 50 feet?
No.
Is any of the new construction, no.
Okay,
No, Paul tends to cite anytime there's a pre-existing non-conforming and they're doing any work on the house, even though we're not kind of going into the rear yard setback.
got it. Yep, okay. All right,
Yeah,
thank
really,
you.
the-
That
oh, of
answered
course.
that question. So,
Thank you. I'll go back on mute.
it's an FAR case. All right.
Yeah, so zoning is straightforward. I'm requesting a finding under 40A Section 6 to increase the existing non-conforming FAR from an FAR of 0.29 to an FAR of 0.31. Again, this equates to a little over 1,200 square feet. And they're also required a special permit under 8.02 of the zoning bylaw for alteration or extension of a structure with non-conforming FAR and rear yard setback. That's really where it comes in under 802, Randolph. Anything
Mhm.
non-conforming, they put the FAR and the rear yard setback, so that'd be a special permit under 802. So under 48 Section 6, alterations and extensions of pre-existing non-conforming structures may be permitted, provided the board finds two things. One, there's no substantial detriment to the neighborhood, and two, that there are no new nonconformities. As you just saw, there's no new nonconformities, and I know that the board has looked to 905 to determine whether there is any substantial detriment. I suggest to you the specific site is appropriate location. It's a large single-family residence in an area that has a lot of large single-family residents. The use will not adversely affect the neighborhood. There hasn't been any opposition. Nobody's expressed any concerns. There's no nuisance or serious hazard to vehicles or pedestrians. There's no changes to the existing traffic circulation. Adequate and appropriate facilities will be provided, and there'll be no effect on the supply on housing available for low and moderate income people. So I think this is pretty straightforward finding under 48 Section 6, and would ask your support.
Thank you. Members, before we go to public comment, any questions for the applicant, Steve?
I have no questions. Thank you.
Wadner?
I don't have any questions.
All right, Cameron, let's see, are there members of the public present who'd like to speak first in favor of this project?
I do not see any hands raised.
So none opposed either?
No.
All right, so we will then hear from you with the planning department and planning board report.
Yep, the planning board recommends approval of the site plan prepared by Sean M. Riley, PE, dated November 19th, 2025, and architectural plans prepared by Michael O. McClung, RA, dated November 25th, 2025. The planning staff, subject to the following conditions. Prior to the issuance of a building permit, the applicant shall electronically submit final floor plans and elevations stamped and signed by a registered architect, and a final site plan stamped and signed by a registered engineer or land surveyor to the Director for Regulatory Planning or designee for review and approval. And two, prior to the issuance of a building permit, the applicant shall electronically submit to the building commissioner for review and approval the floor plans, site plans, and elevations displaying the approval stamp for the Director for Regulatory Planning and evidence that the Board of Appeals decision has been obtained from the town clerk's office by the applicant or their representative and recorded at the Registry of Deeds.
Thank you. All right, the board is going to deliberate now. We have, as the applicant points out, we've got two special permits, one for FAR and one for the alteration under 802. Steve, would you like to start tonight?
Sure. Based on the presentation, it does appear that there's no new non-conformities with this project. And my contention is in agreement that there's no substantial detriment to the neighborhood. So I would be supportive of this project.
Thank you. Wadner.
I agree with Steve, and I have nothing more to add.
All right. I will add only just because I like to read this because I'm picky about the wording. I would like us to find that, I'm quoting here, the change, extension, or alteration shall not be substantially more detrimental than the existing non-conforming use to the neighborhood. In my opinion, that condition has been met. I accept the applicant's assertion that the 905 conditions for grant of a special permit are likewise met, both for the Section 6 relief and for 802. So I'll vote in favor, and that makes it unanimous. A grant of relief, unanimous decision of the board to grant the requested relief, subject to the conditions that have been read into the record.
Did you actually take
Thank
a
you
vote,
very much.
Randolph?
Sorry?
Did you actually take a vote?
Well, you know, you come to a lot of these, Bobby. You will see us, you know, express our recommendations serially like that. We're capable of taking votes. So we.
I just didn't know if there was a vote, and I just dozed off for a second there.
Oh, okay. Well,
I
that's
just didn't.
always
I didn't see there was a vote between the three of you. That's all.
that's always a risk.
Yeah.
Well, you would have noticed because it would have been a roll call vote, but we did hear from all members,
Thank you.
and they are unanimous. All right, moving on to the next case, which is.
Thank you all and good night.
Thank
All
you
right.
all.
Thank you, Mr. McClung. Another one with 5 zeros, number 2025-000004. I got that right?
Yes.
No, sorry, 2026-000004. This concerns property at 1618 Beacon Street, where the project is to expand a roof deck at the front of the 4th floor. Who is here as the applicant or in the applicant's behalf?
I am, Mr.
Mr.
Chair.
Allen again, and will you again waive a reading of the public notice?
I will. Thank you, Mr. Chair.
Thank you. Please tell the board about this request for relief.
Great. For the record, my name is Robert Allen. I have a law practice 300 Washington Street in Brookline Village. Here with Roger Sherman, who is the owner of the property, and Gary Hendren, who is the architect. Just by way of background, 1618 is located in the G175 district, 4-story mixed-use brick stone building, right in Washington Square, essentially. 6 units were approved by special permit in 2020, not that long ago. The proposal is to expand the roof deck outward towards the street. The existing roof deck was approved by the ZBA in August 2020. Case number was 19057. As part of a larger renovation and addition, and although the design of the deck looked good on paper, there was a strong preference to enlarge the deck to make it more functional in practice. The building itself has 0 lot line setbacks. The proposed front yard setback of the deck is 2.2 feet, and the proposed side yard setback is 2.1 feet, where sections 5.52 and 5.62 require a minimum front yard setback of 6 feet. The total area of the existing deck is 224 square feet, and the proposed would be 452 square feet. Obviously, they probably want more space for the marathon, right, when they're watching it on Beacon Street there. Setback relief is available under 5.43 if counterbalanced amenity are provided. The proposed counterbalancing amenity is to line the edge of the roof deck with planters, as has been the preference of the planning board in the past and supportive of this board in the past. Design review is also required because it's on Beacon Street. The planning board recommended unanimous approval on March 5th of this year. I have Gary here, Mr. Chair, if you want him to walk through anything, or I can jump into zoning, your preference.
You mean about presenting the design?
Yes.
Yeah,
Yes.
let's see about that. I saw the drawings. I don't need it myself, but I will ask the members. Steve.
I don't need to see it again. Thank you.
Okay, Wagner.
I'm good. Thank you.
All right, I think we can hear about the zoning.
All right, to summarize, the setback relief is required for the front and side yard setbacks under 5.52. The required front yard setback, as I said, is 6 feet. The proposed is 2.2 on the front and 2.1 on the side. The applicant has satisfied the requirements for design review with the approval from the planning board and meets the standards for community environmental impact and design as described in the staff report. Counterbalancing amenities in the form of planters around the edges, as you see in the drawings of the deck, will provide visual interest from onlookers at street level and will provide partial screening of the roof deck. I'll note that there is a sequence of similar sized roof decks right in this block, right in this strip actually. So the proposal is consistent with the neighborhood pattern. With that, I believe the project meets the following special permit requirements. The specific site is appropriate location for such use. Clearly on Beacon Street above a residential building, its roof decks are pretty consistent and more consistent over the last few years. The use will not adversely affect the neighborhood. There's been nobody in opposition to having a roof deck up here. The neighbors actually have roof decks. There will be no nuisance or serious hazard to vehicles or pedestrian. It doesn't change anything relative to the vehicles or the vehicular access. Adequate appropriate facilities will be provided for the roof deck. The proposed roof deck will be accessed from the existing roof deck stairway and there'll be no effect on the supply of housing available to low or moderate income people. So I suggest to you that this is great. This is additional open space on Beacon Street in a busy area where there's not a ton of open space. This gives them a little more breathing room up on the roof. So I suggest to you this is a worthy project for a special permit, and it meets 905 standards. Thank you.
Just a question about the counterbalancing amenity. Are these the planters and so on, are they actually visible from down below?
Gary, did you actually do one of those that you usually do when you're standing on? I know they would be visible
Yeah,
on
we-
one side of the street, but maybe the other side.
Yeah, we have a section showing the line of sight, if you want to see that.
Well, just why don't you tell us what it shows?
What it
No,
shows is
It's a drawing. Let's look at it.
Okay.
So if Cameron, if you could allow Rajvi to take the screen.
Roger Sherman.
Rajvi,
Oh,
R-A-J-V-I.
okay.
I mean, this building,
What's that?
it's a row building, but it sets back to the next
Yeah.
one, right? So
Yeah.
maybe there's a view from one side or the other.
Yep.
Okay.
Oh,
you can
I see. There we go.
You see the little person standing there. You'll probably be able to see the planter is on the outside of the railing, so you'll be able to see a little bit of green, but you won't be able to see the railing.
But if a person is walking up the Beacon Street sidewalk, say from Coolidge Corner, they'll see I mean, in the right side drawing, they'll see that part of the building for quite a ways, right?
From up the street, again, if you go to the plan, there's planters along the side also. So again, what they'll see is some green growing up on the roof.
Okay, thank you. That answers my question. And I think we can take the drawing down. Members, any other questions for the applicant or the architect, Steve?
No questions, thank you.
I
Wagner?
don't have any questions.
Okay, let's see if there is public comment. And there was at least one letter of support received by planning through email. Cameron, is there anybody in the hearing who would like, member of the public who'd like to speak in favor?
I don't see any hands. No.
And nobody opposed?
No.
All right, so let's hear the report of the planning department and the planning board.
All right, the planning board recommends approval of the site plan prepared by Joseph R. Porter, PLS, dated March 4th, 2026, and the architectural plans prepared by Gary Hendren, RA, dated November 12th, 2025, subject to the following conditions. 1, prior to the issuance of a building permit, the applicant shall submit consistent final plans and elevations prepared by a registered architect, subject to the review and approval for the Director of Regulatory Planning. 2, prior to the issuance of building permit, the applicant shall submit a final site plan prepared by a registered engineer or land surveyor, subject to the review and approval of the Director for Regulatory Planning. 3, prior to the issuance of a building permit, the applicant shall electronically submit a final landscape plan, subject to the review and approval for the Director of Regulatory Planning. The counterbalancing amenities must be executed in accordance with this approved plan. And 4, prior to the issuance of a building permit, the applicant shall submit to the building commissioner for review and approval for conformance to the Board of Appeals decision, a final site plan stamped and signed by a registered engineer or land surveyor, final building elevation stamped and signed by a registered architect, and evidence that the Board of Appeals decision has been recorded at the Registry of Deeds.
Thank you. All right, the board is going to deliberate now. What do you think, Wadner? Would you like to start this one?
Yes, the applicant make a good presentation, and the reason why they undertake the project, the propose, and it seems like the project does meet the requirement of 905 and the functionality of it. So I like the part that whenever we're gonna have the Boston Marathon, the people will be able to use it. I think it makes sense, and I like that. So I'm in favor of it.
All right, thank you. Steve?
I also have a yes vote in case we had any doubts about a vote, but
No, we're coming to that. Hang on.
my view is that it meets the qualifications under 905, and it seems to me that this is perfectly consistent with the other buildings along that street, and the counterbalancing amenity to me makes perfect sense. So I'm a yes vote as well.
All right. I intend to vote yes also. I'm just going to add that I think we should find that specifically that this project does comply with the subparagraphs B and C of 5094, the Community Environmental Impact and Design Standards, for its well worked out relationship to the streetscape of Beacon Street. And we're going to do a roll call vote, like because we said we would, on the motion to grant these two special permits with the findings that members have stated. I'll move it. Can I have a second?
Second.
Seconded by Wadner. On the motion, Steve Brooks,
Yes.
Wadner Rajay,
Yes.
and Randolph, the chair votes aye. It's
Thank you all
unanimous
very much.
decision of the board to grant the requested relief, subject to the conditions read into the record.
Great. Thank you very much.
Okay, thank you. All right, making good progress here. All right, with 5 cases. Fourth case this evening is number 2026-000008. This concerns property at 90 Ivy Street, where the petitioner's request is to modify, to request that the board modify its previous decision to allow the conversion of living space to an accessory dwelling unit in a detached garage. I'm going to note for this case, and I believe the next one, we're joined by representatives of the Office of Town Council. If those two staff members are available and ready, if they would just introduce themselves. Mr. Simpson.
Good evening, Jonathan Simpson, First Assistant Town Council.
Thank you. And Ms. Harris?
Hi, good evening. Susan Harris, Associate Town Council.
Thank you. Members of the board, I just want to note that Jonathan and Susan are here to answer any questions you may have in the course of the hearing, for example, about the applicability of laws and regulations to the project. Just make sure I've got the right, this is okay, fourth case. Now, let's hear from the applicant. Mr. Allen, are you here on behalf of the applicant again?
I am, Mr. Chair.
Yes, and for this case, will you waive a reading of the public notice?
Yes, I will.
All right, please tell the board about this request.
Sure. Again, for the record, Robert Allen, 300 Washington Street in Brookline Village here, representing Dan Adelson, who Adco Realty is the owner of the property. So just a little background, the Zoning Board of Appeals granted special permit relief and finding on March 7th, 2024 to construct a detached garage with living space above, extend the existing driveway and enclose an entryway at the front of the existing single-family dwelling at 90 Ivy. The decision was filed with the town clerk on March 29th, 2024, and an appeal was filed and the case is pending in Norfolk Superior Court. To me, our request tonight is pretty straightforward and really has nothing to do with the litigation, which I personally am not involved in. Essentially, in the 2+ years of litigation, the law changed, which offered an alternative layout and use for the structure as a protected accessory dwelling unit. So the garage no longer needed relief. We could use as an ADU pursuant to 70 CMR 71. We've heard from both the state and the town about the benefits of ADU, that they add significant value and meet the growing demand for this type of housing, whether for extended family, adult children, or caregivers. A building permit application for a protected ADU with a kitchen and bathroom and the required 13D sprinkler system was submitted and approved by the building department on February 2nd, 2026. Just by way of background, I know the chair sat, but I believe the other two members did not sit on the original meeting. The board original decision granted relief under 48 Section 6 to increase the existing FAR from an FAR of 0.4 to an FAR of 0.45. This included 569 square feet of the living area above the garage and 45 square feet entry foyer for the primary structure. The 569 square feet of living space in the garage is now permitted as of right as a protected ADU pursuant to 760 CMR 71.032D. And as this board knows from prior, ADUs are not counted in any density calculation, so it does not go towards the FAR. The prior decision also granted relief under zoning bylaw section 5.43 for dimensional relief. The rear yard setback was reduced from the required 40 feet to 12 feet, and the side yard was reduced from required 20 to 10 feet. The zoning bylaw section 5.72 provides an accessory structure shall be set back by a minimum of 6 feet from the side and rear lot lines. The proposed structure is set back from the side, currently set back 10 feet, and on the rear, and 12 feet, 10 feet from the side and 12 feet from the rear. Therefore, relief for the rear yard setback for the protected ADU shall not be required in accordance with 760 CMR 71.033B2, which states in relevant part that any requirement concerning dimensional standards such as dimensional setbacks cannot be more restrictive than those required for an accessory structure in the zoning district where the protective use ADU is located. It should be noted that this section of the CMR was confirmed by the Attorney General's office based on this very fact pattern. Accordingly, the Attorney General's office has confirmed that the existing setback for the garage and ADU comply with the applicable CMR regulations as permitted under the town bylaw, to wit, the 6-foot setback under the accessory dwelling unit. So the request is pretty straightforward. We're asking the decision 2023-000070 be modified as follows. 1, to rescind and delete the portion of the ZBA decision that granted relief for side and rear yard setback, which pertained to the detached garage, as well as the relief granted for the living space above the garage. Second, that all other relief granted in the ZBA decision shall remain in full force and effect, which, just to be clear, would mean that the 40A Section 6 finding in the original decision be modified to only allow an increase in FAR for that 45 square foot entryway foyer, that the setback relief for the driveway was granted in the original decision will remain unchanged. And finally, it should be noted that all prior conditions in the original decisions, like counterbalancing amenities, which technically wouldn't apply to an AD, they've already been complied with, and they will remain. So it's pretty straightforward, and I really think it has nothing to do with the pending litigation. It's just the law changed, and client decided to take advantage of the ADU. And the other thing I just want to point out, it's actually important that it be taken away as a special permit and put an ADU, because the ADU does have some restrictive terms. For instance, the ADU has to be the same ownership. Second, the ADU has to continue to be used as an ADU. So they can't just take the bathroom out or do anything like that. So it's important that the record reflect that, which the building department's record will reflect, that this is now an ADU. And what I'd like to do is take this out of the chain of title, which shows that a special permit was granted. So once this decision, if we're able to get this decision, we will file something in the chain of title to make it clear that that special permit is no longer there, or that finding is no longer there for that use, and that use is now an ADU, which I think is important to preserve on the record of this house. So I hope I've been clear, and I'm happy to answer any questions.
Thank you. Let's see if members have questions. Steve Brooks?
Thank you. I don't actually have any questions. I read all the materials and familiarized myself with the new CMRs, so I don't have any.
Okay. Wadner?
The only question I would ask, it's the town council to clarify exactly whether that the request is permissible to modify the prior decision and to remove the initial restriction. I don't know whether maybe the applicant clarified that whether we have the increase whether there's an increase of FAR or it's already protected, the increase is already protected.
So Wadner, is your question for the for
Yeah,
town
whether
council?
the town council can clarify what exactly the board yeah, can do with in terms of modify the existing decision based on the council presentation.
Sorry, Jonathan,
One-
would you like me to hop in on that?
Sure, go ahead.
Sure.
All right, thank you.
Sure. I'm trying to understand the question. I think you're asking about the piece regarding the FAR. I think I heard. My understanding is this request is actually to minimize the relief that was granted in the original special permit. So the original special permit granted relief for a larger increase in FAR because it was including the living space that's now an exempt use ADU. So it's now the request for modification is to provide less relief than before.
So basically, we
Was that
can
your
just-
question, Wadner? Are you asking
Well-
about what authority we have as a board to modify decisions that
Yes,
we've
yes,
made?
that's, yeah.
Okay. So can projects change and can we modify our relief that we grant to them?
Jonathan, do you want to answer more generally?
Oh, sure. Yes. Under Chapter 40A, the board has the ability to modify previously granted permits as well as conditions therein. This extends, in this case, to the ability to modify the findings you make under Section 6. As Susan said, you do still have to make a finding under Section 6, but it will be a modified finding in this case because it's over a much smaller area. But you do have that authority. Yes.
Got it.
Thank you.
Does that help, Wadner?
Yes.
Okay. Are you all set? You have anything for the applicant?
Well, the next question is, I understand there's a legal action pending related to the prior decision. It just, I don't know if the board were to modify today and render a decision, what impact that will have on the pending litigations. Would that change that, or?
I'll defer to Jonathan on that since he's more involved in the litigation than I am.
Wadner, can I suggest this? Can we ask town council whether we should focus on that, think about that much, or should we stay within the question of relief and modification that the applicant has brought to us?
Yeah, I agree. That's fine.
All right. Jonathan or Susan, what do you think?
I think you can deal with the request that's before you. I can let you know that the court is aware of the request for modification and the building permit appeal that's next on your agenda. So we will be providing an update to the court. The matter has been stayed for now to allow the ZBA to conduct further proceedings.
Okay.
Thank you.
Thank you.
Okay. All set, Wadner?
Yes.
Yeah, I just have one question back to the applicant. And this is about the counterbalancing amenity. Bobby, tell me if I'm remembering this right. In the original design and the original grant of relief, there were a couple of items of dimensional relief, but I think there was only one set of counterbalancing amenities that might have addressed all of them. And you've said that I don't remember what that actually is, and I think you've said it's installed. Can you just talk us through what's there?
Yeah, I know there was installation of ivy. There was additional stormwater mitigation because there was some concerns about water going off the property, so they increased the stormwater requirements. And then the board wanted, I think the ZBA wanted to see some ivy planted in the back of it. And there was also, I think, a change in window location, which I'm not sure was the counterbalancing amenity. That's to my memory. Again, no counterbalancing amenity is required under this new finding for just the foyer.
But for the design of the driveway has not changed. So
Yeah,
the
but
relief,
that would also be 40A Section 6. There wouldn't be any counterbalancing amenities required under that because it's a pre-existing non-conforming condition that we extended under 40A Section 6 also. The 5.43.
oh, that was
requirement
pre-existing. Okay.
Yes, the 5.43 related to the side yard and the rear yard setback of the garage structure.
Okay, so thank you. That's helpful. But let me go back and ask you, in zoning terms, do you believe that any counterbalancing or amenities are required in association with the relief you now request?
No, because now we're only
All right.
asking for a finding relative.
Thank you.
to the-
Yeah, got it. Okay.
Thank you.
Um,
That was good. Thank
let's see. So I think I just want to make sure members are okay with this. Do we need a presentation of the design or to see the site plan or any drawings? Start with you, Steve.
No.
No. Wadner.
No,
No. And I don't think I needed either. I thought the materials in the packet were pretty complete. And Bobby, you done with your zoning argument?
Yes,
So we
thank you,
can
Mr. Chair.
Move to public comment. All right, Cameron, have we got members of the public present who would like to speak in favor of the project?
I do not see any comments or hands raised.
Okay, any members of the public who would like to speak in opposition?
I don't see any, no.
All right. Now, my understanding is that we don't have, just because of the nature of this request, just for the modification, we don't have, it didn't go to the planning board. We don't have a planning board and planning staff report about it, correct?
No.
Okay. At this point in the process, this is normally when we would hear from the building department. I don't think representatives of the department are present. But could I ask if town council met with the building department, do you have anything to convey from any of your recent conferences with them that would help the board at this point? Actually, pause. I'm going to pause that question because Cameron, we've got a hand raised from David Chaffin.
You should be good to unmute, David.
We're not hearing yet, Mr. Chaffin.
Can you hear me now?
Yes.
thank you.
Are you
So-
speaking in public comment?
I was, and I'm sorry I didn't get the hand up quickly.
Okay, that's all
enough.
right. We're
Okay.
just stepping back a minute to continue public comment. Just
Yeah.
for the record, are you speaking in favor or in opposition?
In opposition.
All right, thank you. Please introduce yourself and go ahead.
Sure. My name is David Chaffin. My address is 101 Arch Street in Boston, the firm of White and Williams. If I may, as you may know, members of the board, I submitted the appeal that's the subject of the next matter, and it
Yes.
might work out more efficiently if I address our concerns then. It's all one package. I could do it now, or I can do it then, whatever you prefer. But we are certainly opposed to this application.
If I would like to hear from you now while the board considers any comments that you have about this request, the case that we're on right now, the request for the board to modify its previous decision in relation to the change in the project. Do you have any comments on that? Because I really do. We're going to keep these in order and separate.
Yeah, it is sort of part of the same package, especially, I believe that now that I'm hearing Mr. Allen's presentation, that basically the restrictions that were imposed through the special permit are now lifted because of this application for an ADU. So I think logically it would make sense for me to just go ahead, if I may, and just incorporate by reference my comments in connection with the appeal. So what I'm going to say, yeah, is essentially an attack on the building permit, which is an attack on the request to modify the special.
I really am going to ask you to stay away from the building permit, which is
Okay.
in the next case, and we're not talking about that yet.
Okay. So I'll just summarize very quickly, if I may. What I'm hearing is essentially that this application is to basically gut the special permit and all the restrictions, the restrictions in the special permit, which we believe is because this is an ADU application, and the suggestion is there's protection for this entire structure now with respect to the relief that was granted back in 2024, and which is being challenged, and we are confident we're going to invalidate just because of the suggestion that, or based on the fact that part of the building is going to be an ADU. The special permit should stand. The relief that was requested at that should stand in that in the sense that the relief that was sought needed to be sought and needed to be obtained. We believe that it is invalid. I think you know that from the submissions we've made. The special permit, it's got a handful at least of flaws, but the suggestion that that relief is no longer required is, we believe, incorrect because it's all premised on the ADU on this ADU application. The ADU application does not, in our view, moot the requirement to get relief with respect to most of this structure. The ADU is only part of it. So anyway, the permit we believe, should not be modified this way. It should stand. Let us go through the Superior Court process and then consider in the next matter what to do about this building permit. I hope I'm clear on that.
Yes, thank you.
Oh, and may I say one more thing, please?
Yes.
And this is important. I'm not sure that it'll disrupt the process here, but please, if there's any opportunity, perhaps through a postponement or an adjournment or a continuance, please go take a look at this project. Take a look at it from the 90 Ivy side, take a look at it from the 15 St. Mary's side, and you will see what our concerns are and what's being done here, leveraging this ADU to build a much more massive structure right on the doorstep of my client's property, right on the doorstep of Ms. Taylor's residence. Thank you.
Thank you. I will respond just briefly to your last request because I'd like to get around town. I do go to almost all of the sites, and what I found today was that the conditions that I saw are very well represented in the photographs that you provided and the material that were in the board's packet. Cameron, are we done with public comment, or do you see any other hands raised?
I do not see any other hands raised or any other reactions.
Okay. Let me go back to where I was a minute ago, which was, and this is only if town council would like to share some comments, but because we don't have a building department representative at this hearing, if there is anything that might benefit the board's deliberations that you could share from your conversations with the building department, this would be the time to do it.
I think that the critical thing with respect to this matter would be that the building department was adamant that the garage standing alone does not require any sort of the relief currently in the special permit. So in the building department's view, you now have effectively a garage that does not require special permit relief and an ADU that is exempt from any special permit requirements. So that sort of makes the modification request itself evident.
Thank you. Board members, any further questions for the folks from town council's office? Because I think when we deliberate, we should be on our own and have them sit back. Steve, are you okay?
I just want to clarify one thing, Mr. Chaffin, if you could answer this question. I know that you have an opposition to the erection of the garage and the ADU structure. Do you have an opposition to the remaining the part that Attorney Allen is asking to remain, which is the vestibule build out? Does that are you in opposition to that part, or just the garage and the ADU part?
We're not opposed to that, and I will say that we're not categorically opposed to what's being presented by IBD here. There are modifications to this structure that would address some of the concerns that could be made, that have been proposed, that perhaps could be imposed by condition. We're not categorically saying knock it down. We haven't said that, but we're being driven to that position right now because right now we're at a fork in the road. So anyway, I'm sorry, long-winded answer. We're not opposed to the vestibule changes or the driveway. It's just the structure.
Thank you.
Thank you.
Steve, anything for town council?
No, thank you.
How about you, Wadner?
I just want to ask Attorney Chaffin, are you saying that the board doesn't have the authority to modify this?
No, I'm not.
Wadner, we have town council here. I think if you, as a member of this board, if you want to receive opinions about your authority, I think that's why town council is here.
No, I understand, but I think I heard something about, we shouldn't modify this. I know I did ask town council that question, but I just want to, well, I'll just leave it that way.
All right. Thank you. We're going to deliberate now. I think I'm going to start on this one. When I look at this request, I think what we've got here is we have project under construction, having been granted relief by this board from certain sections of the bylaw a couple of years ago, and the petitioner is making a change to the project, which leads to this request to consider a corresponding change in the relief. And we do get these changes from time to time. It could a change in a project could lead to a request for more relief, or it could be less. And what we've got here is a change in the use that the petitioner believes will require less relief than the original project. And from my point of view, I can't see a reason, either in the interest of the bylaw or in protection of the public interest, to deny relief to a project that proposes now to become more compliant with our bylaw. So I'm inclined to grant this request. And if other members would like to join me, and we are going to vote this one at the end, but we could do it on a motion like this, to modify the prior grant of relief in case 2023-000070 as follows. Under FAR, to continue to provide the relief granted under Section 6 while recognizing what's now a lesser increase to the gross floor area in FAR, only the 45 square foot front foyer addition, because we continue to find that the proposed structure with this modification is not substantially more detrimental than the existing non-conforming use to the neighborhood. That's the first item. The second item is to make no change to the relief that we previously granted for the side yard setback for the driveway. And the third is to delete the special permit relief granted for the side yard and the side yard and rear yard setbacks for the new garage structure, which are now unnecessary because of the change of use. So that's my proposal, and that whole last part is motion. We can discuss it, and then, like I said, at the end, we're going to vote at the conclusion of our deliberations. Wadner, let me go to you next.
I do not have anything more to add. It's they use the applicant requested, it's protected, and they just, the propose, it's a reduce. FAR they're requesting previously was 569, now currently it's 407. So I don't have any. I think it's within the board purview to decide whether to grant that use, and then I'm in favor of granting that.
Thank you. Steve.
Thank you. I would agree with what both of you had said. We're going from a less compliant situation to a more compliant situation. I have no issue with granting the request as worded.
Thank you. Then we're going to vote now. I'm going to make that motion. I won't read it again, but it's the motion I made in my comments with the 3 points. Is there a second?
I second it.
Seconded by Wadner. On the motion, Wadner Roget,
I do.
Steve Brooks,
Aye.
and Randolph, the chair, votes aye. It's a unanimous decision of the board to modify the prior decision as I read in the motion. Yeah.
Thank you very much.
And that's it. That concludes this case. We will stay at 90 Ivy and move to the next one. Fifth and final this evening. Another long number, 2026-000009. Again, concerning property at 90 Ivy Street. This is a petition made by 15 St. Mary's LLC and Sarah Taylor. And it is an appeal of the building commissioner's issuance of a building permit for an ADU at the 90 Ivy Street address. Let me call on who is here as the petitioner on behalf. Is that you, Mr. Chaffin?
It is I. Thank you.
Yes. Will you waive a reading of the public notice?
I will. Thank you.
Thank you. Please tell the board about the appeal request.
Thank you. Again, my name is David Chaffin. My address is 101 Arch Street at law firm of White and Williams, 101 Arch in Boston. So we are appealing the issuance of a building permit here. We submitted a lot of material to you about the background of the litigation and the background of the permit, which now has been modified. And unfortunately, some of what I'm about to say is going to overlap over the last presentation. There's going to have to be some commentary if you don't mind. I understand that this is the board's decision, but it's going to happen. So there was some reference to counterbalancing amenities here. The only counterbalancing amenity, and this is an issue of concern in the litigation, I am involved in that. This was an issue of concern. The only, in any way, could be considered counterbalancing of the concerns here was planting ivy along the building, which has absolutely no counterbalancing effect. And I know this is an issue of concern in the court. So we have that. And one other comment I'd make. I don't believe, I'm unaware of anything in the record that indicates that the building department actually found or indicated in connection with the building permit that the garage part didn't need any type of zoning relief at all. And that's really a key issue for us. So with those couple of footnotes, I want to repeat again, please, if anyone who hasn't seen the project and has an opportunity to go take a look, please go take a look and consider how big this is, how close it is to Ms. Taylor's home, to the windows, et cetera, and where the windows are going to be if this is completed as they're proposing to complete it, which is in a very quite different way from what was being proposed in connection with the special permits 2 years ago. Now these are going to be full-fledged windows with a view right into Ms. Taylor's property. Please go take a look. So some of the background, we know about the permits. I'll skip a lot of that. And I think you've got the background of what's going on in the Superior Court. The court is indeed aware of it. What's going to happen in the court, I don't know. We know there were concerns with respect to the special permit and some of the findings there. I'm going to jump to the concerns and I articulated, and I hope hopefully clearly in our papers about the real frustration we've had with the fact that this approach, the ADU approach, was just mentioned to us in February of this year, notwithstanding that it was being pursued for about a year. So this is of concern to us. So we're now trying to get up to speed, piece together, what the ADU bylaw is, what the intent is, and things of that nature. One thing I would say, tried to piece together what existing pieces of the ADU bylaw are at this moment, and what the intent and what the purpose. I will say, with respect to the purpose of the bylaw, this project, it glances off of them at the most. It doesn't promote them except tangentially, and it certainly wasn't. If this were really this developer's intent and desire in connection with this project, it would have been what they were pursuing 2 years ago. The bylaw, the Brookline bylaw, was passed at least 1.5 years ago, but that wasn't the intent until announced in February and sought in January, I think. Anyway, so a little bit of skepticism about the intent behind this and whether it's going to serve the purposes. So very difficult to piece together what the ADU bylaw is right now. You've probably noticed the bylaw, the statute passed, the town passed the bylaw. The bylaw underwent Attorney General review. A lot of the provisions of it were knocked down, as we know, but there are provisions that are still standing. If it were the old bylaw before the town passed the new one, this project would fail. Even under the current one, we submit it fails, and for a number of reasons. There are, again, existing pieces of what passed in 2024. And now, as you probably know, there's a new bylaw that's going to be brought up at town meeting. Not applicable at this point in time. If it passes at town meeting, I suppose it will go into effect at that point in time. But right now, we do have some remnants, some pieces of the bylaw. Our first concern with this building permit and what's being attempted here is that it's basically the building permit and the request to change the use is being said to make this. It's actually not a change in use because it was going to be living space, just not an ADU. Is that it's basically being used as almost a carte blanche to do whatever they want with the rest of the project. Again, that just can't be right. And you can think of the problems that could be created with that, the mischief that could be done if projects like this were permitted. Sticking an ADU into an illegal, non-compliant structure like this and saying the rest of it is fine and it doesn't need any zoning relief, that just doesn't make sense. And I don't believe that the bylaw says that now. In fact, there is a limitation in the bylaw, as I think you probably all know. An ADU can only be, at most, with a special permit, 950 square feet. The building permit was sought, premised on the fact that just the upper part of this garage was counted against that 900 square feet limit, with 950 with a special permit. In our estimation, that was incorrect. This entire structure needs to be considered. Why? Because the definition of the current bylaw says you need to look at all habitable space in the building, in the structure that's involved. And that so-called garage area there is very close to, with some minor tweaks, habitable space. It's walled in. We believe it meets the definition. Moreover, the application had, I think, I've forgotten what the square footage was that was presented to the building department. It's not correct. There's a utility room on the first floor, even assuming you don't count the whole garage. There's a very large part of that first floor that's a utility room. The definition of habitable space, the utility room is counted as well. I don't know what the final math is at this point, but the point is it wasn't presented to the building commissioner. And also the plans presented don't show a kitchen, which is required for approval of this. But the larger concern really is the kind of leveraging of this ADU and getting relief with respect to the rest of the structure. I've heard it said that the rest of it didn't need any relief, but yes, it did. It's not an accessory structure because of its height. And by the way, the application for the permit to the building department said it was only 20 feet high, 20.9 feet. It's actually 23 plus feet high, which is going to have some significance under the proposed bylaw. But the point being, the garage area is still suffers from the same defects with respect to side yard and front yard. How can that be ignored just because the upstairs is now going to be, or they want it to be, an ADU? It's still a non-compliant structure. It's either part of the ADU, in which case it's too big, or it's not part of the ADU and it needs to undergo some sort of zoning review. Side yard, back, rear yard, height, whatever. But that is not being sought, and the claim is that isn't necessary at all. That's incorrect. So if looking at it, if then you break it down, and I think this is a corollary to what I was just saying, consider the ADU alone, it gets a pass, basically very minimal zoning relief, but there is some. You look at the patchwork, that gets a pass, but look at the garage. Again, the garage is non-compliant. If it were compliant, they wouldn't have needed the special permit that they got 2 years ago because of where it is situated. So this is our view is that the permissive approach here, that you look at the most permissive parts of the zoning bylaw, and those apply to every part of the structure, just isn't correct. But if they're reading this to say, for example, the 6 foot rear yard setback requirement is going to be applicable in all instances, which is in this district and many others, that is leading with the chin to a constitutional challenge to the regulation. I mean, how can that be? How can it be that the reg permits a 30, 40-foot story building just because it happens to have an ADU in it, 6 feet from the property line? It could be right on somebody's living room, like Ms. Taylor's here. So that we will be looking at down the road. So, but again, granting them that the most permissive approach applies. There's an admission that there's at least 6 feet. There are sections of the zoning bylaw that are still in place that have been completely ignored in connection with this project. Sections 5.03 and 5.04 require a full front yard in front of a project, a structure like this, and a full rear yard behind the principal dwelling. 12 feet here, even assuming it's a 6 foot, the minor setback. It's not. They're 9 feet apart. They do not that does not comply with that. There's no evidence that the building commissioner considered that. It wasn't, and it wasn't considered in the prior proceeding here. And it hasn't been addressed. It's violative of that provision. And that, if they're looking for a special permit on that, it hasn't been sought. Furthermore, section 4.05.3, point B, point 2, point E imposes a screening obligation. Whenever the height or setback requirements as of right aren't being met, which is the case here. The screening requirement has not been met in connection with this building permit. There's been no compliance with that, and no suggestion that that's going to be complied with. There are some other concerns that we raised in our papers. There's the second means of egress. I think that's probably moot. It's not in the bylaw. The Attorney General did address it. And the errors in the application, some of the data that was provided to the building department and in the applications here today just aren't correct. I mean, this is not a genuine and a true rendition of what this project is going to do, but particularly the living space without the kitchen, et cetera. And there are certification requirements that haven't been met. So anyway, in conclusion, this building permit was invalidly issued. It's trying to use the ADU bylaws, statute, and regulations. Admit they are pro developing housing. I get that, but not here, not like this. They can't be leveraged to allow a project like this, a massive project like this, where most of it is a garage. That's a misreading of it and a leveraging that's not contemplated. And there aren't provisions in the bylaw that in the bylaw or in the regulations that would permit something like this, because this isn't. There is a part of the regulations about pre-existing non-compliant structures that can't be used as an objection here. This is not a pre-existing non-compliant structure. The pre-existing non-compliant structure here, based on which this board provided a special permit 2 years ago and is about to modify that, is the house. It can't serve double duty, and it isn't a structure. It doesn't have a permit, no certificate of occupancy. It's not completed. That is no saving of this building permit. Please invalidate it. This is not an appropriate use of the ADU statute, regulations, and bylaw, and particularly with a major change coming up. And if this is not the time to start creating laws like situations like this where people can jam ADUs in major buildings and put them right in somebody's lap. Thank you. I appreciate your patience on this.
Thank you, Mr. Chaffin.
Thank you.
I'm going to call again on the representatives of town council, and just to try to set it up for you. As you may know, this board doesn't hear building permit appeals very often. ADUs themselves are relatively new in our regulation, state and local level. And the building commissioner isn't with us this evening. And I wonder if, following Mr. Chaffin's presentation, one or both of you could maybe just for the board summarize the applicability of the state law, about ADUs, any provisions of the local bylaw that became unenforceable, maybe just some examples of those when the state law went into effect. And then specifically, if you could comment on if this was, a part of your conversation with the building commissioner, any comments about Mr. Chaffin's suggestion that the garage area is in some way could be or should be considered, as to be joined to the ADU. Let me stop there. And
sure, Susan, if I'll take it if you don't mind.
Sure.
Thanks, Jonathan.
So yes, so I think critically the first and most important aspect of this to remember and is unfortunately, and I understand Mr. Chaffin's sort of incredulity about it, is that the notion that you take the most permissive dimensional requirement and apply it to a protected use ADU is exactly what the state and it's the regulations that it's EOHLC has promulgated is meant to do. We are fully aware that this can lead to some results that seem more than a little counterintuitive. If you look at and it's not germane to this hearing, but if you look at the bylaw that is being proposed in order to come into compliance with the state regs, the bylaw that's being proposed for this coming town meeting, we have to allow the most permissive setback that we allow between accessory structures, principal dwellings, and single-family residential dwellings in this district, which is 6 feet from the side and rear lot lines. We have to allow that while simultaneously, and it's not really at issue here, well, I guess it potentially is, while simultaneously allowing the most permissive height for those 3 things. And they can work in tandem to create a situation exactly as Mr. Chafin points out, which is that you can theoretically have a tall structure that's an ADU very close to a property line. That is, we have made multiple inquiries to the state as to whether that is, whether that's an interpretation that is intended, and they have told us yes every single time, and we are amending our bylaw to allow for that. That essentially is why we believe that the building permit, there's no question that the building permit here, when read in conjunction with our bylaw through the lens of what the regulations are doing, is complied with what is required under our bylaw. For example, the applicability of our setback requirements, again, means when you're looking at it with the state law means that we're applying our setback requirements for accessory structures. The garage is an accessory structure, and the ADU also gets to benefit from whatever setbacks are the most permissive, which in this case is also for accessory structures. Those are 6 feet for side and rear lot lines, which means that the structure does not encroach into any of the setbacks. Because it does not encroach into the setbacks, it is also not responsible for providing any screening under our bylaw, because our bylaw requirements for screening only kick in when something isn't providing the required setbacks. And the required setbacks here, again, are just 6 feet. So we have, and you'll, as you go through the sort of list that Mr. Chafin submitted of his concerns with the project, there are not any that we believe that the building commissioner erred with respect erred when you consider what the regulations require, how the regulations require we treat ADUs. There's no insufficient setbacks for side or rear yard. The habitable space is pursuant to the definition of gross floor area found in the regulations. You do not count garage space. The protected use, it is small enough to be a protected use ADU, therefore it is allowed all of the protections from the statute and its accompanying regulations. I already mentioned the screening, and Mr. Chafin has essentially noted that there's no, because it is sprinkler, there is no requirement for a second means of egress. I unfortunately cannot speak to the errors of to the extent there are errors of what the plans submitted were, but at least what Mr. Chafin flagged in his submission, that even if it is 23 feet in height, again, we have to apply the most permissive height requirement for an accessory structure, a single-family dwelling, or a principal structure in this zoning district, and that is well above 23 feet. So even if it is 23 feet, it is still it's still a permitted structure. It's still permitted as of right. The building permit is still valid, notwithstanding the fact that some of the submissions may have been mislabeled. So again, I think at this point there's going back to your original question, Randolph, the applicability of the state law means that the what is left of our bylaw, the AGO is fairly painstaking in striking any limitations of these dimensional requirements to try to impose dimensional requirements like the ones Mr. Chafin is citing that might be applicable to a principal structure, or if you look at our use table, to that third line in the use table, the any other structure or principal use. Those also have large setbacks, which are also not applicable because those aren't the ones we apply to accessory structures. Again, accessory structures are the ones we need to look at here, and those are 6 feet from the property line.
Thank you, Jonathan. That's helpful. And I'm just going to turn back to members of the board for questions. And Stephen, one of these can be questions on the presentation, or they could be questions for town council. Wadner?
Yeah, I have the questions to town council. Are you trying to emphasize that if the garage was not exist, you're still gonna use the setback requirement for accessory? Is that correct?
Yes, that is true. That's exactly right.
So regardless whether the garages exist or not, the garage wouldn't be any. It will just be the same requirement for accessory. That's the setback for accessory. That's what will apply to ADU structures. Is that correct?
For protected use ADUs, yes.
Thank you.
Steve, questions?
I had the same question. I appreciate the answer.
Yeah. Okay. Good. Did I have a question here? Let me just look. Yeah, I think I had mostly questions for town council. I think I sort of got them out before when I asked you to speak, Jonathan. So we will go to public comment. Cameron, can you tell me, do we have members of the public present who would like to speak first in favor?
I do not see any hands.
And any opposed?
No, I see no reactions or anything in the chat.
Okay. And again, because of the nature of this case, we don't have a planning department report. I think we've been getting a fair amount to members of the board. We've been getting a fair amount conveyed through town council of the position of the building commissioner, you know, in detail. You've seen the permit itself. Do you had Steve Widener? Do you have any other questions about the, you know, and again, I'm sorry we don't have the representatives here, but any questions that relate to the building department's action in granting the permit?
I do
Widener.
not.
I don't
Yeah.
have any other questions.
All right. All right. We're going to deliberate now. Let me see. Looking for a place. I'm going to try to start. As I said, I'm just proceeding slowly because I mentioned some of these things are a little new to this board and some members of it, and some new state law as well. But one of the main issues I see is that ADUs are now a by right use. According to state law, you know, Section 3 of Chapter 40A, a by right use in single family residential districts. There's still a building project underway. You know, it's going to need to receive a certificate of occupancy. There's been a change in the project, as we're aware, and the request for the building department for the building permit was made to recognize that change in the use. And you know, typically when cases come before this board, request for relief, we will see a denial letter. So we know what it looks like when the building commissioner denies a permit or thinks there are questions for the board to address, you know, typically for relief. In this case, you know, I look at the building commissioner's action to grant the building to grant the permit, and you know, we've come to rely on the judgment of the building commissioner, his interpretation of applicable law through those denial letters. You know, I haven't heard any testimony this evening myself that causes me to question the grant of the permit. And I haven't heard a reason yet that the building permit shouldn't be allowed to stand. So I'm inclined to vote to deny the appeal, but I'd like to hear from other members. And if I do have a motion that we could consider for when we vote, but let me go to you next, Steve.
So thank you. The inquiry for me is whether the building commissioner applied the necessary standard and being the CMR, obviously the Brookline zoning code and the statute. And to me, unless there's some error somewhere, it doesn't seem that there's any misapplication. We did get the input from Jonathan and Susan, appreciated very much. And it does seem that this protected ADU is to be built as of right, as long as the requirements are met. And so short of that, I don't see how we have any discretion to overturn the building commissioner's decision to issue the permit. The statute controls, the CMR controls, and so it overrides to the extent that it's any different than the prior part of our zoning code.
Thank you, Steve. Wadner.
I do not have anything specific. The only thing that it's showing that the ADU, it's a protective use by right, and there's some requirement that they must meet. under the bylaw, and then whether the requirement is to follow the requirement for accessory. So if, as long as they meet the requirement, I don't see anything on record that's showing that they did not meet the requirement in terms of the setback for accessory. So I'm in favor to uphold the building permit decision.
All right, thank you both. Let me try this for a motion that we could discuss and then vote on. Move that this board deny the appeal dated March 3rd, 2026 of the building commissioner's issuance of building permit number 2026-000064 for the construction of an accessory dwelling unit, an ADU, in the structure at 90 Ivy Street, the new structure at 90 Ivy Street. The board finds, and we could make this a finding, that the building commissioner acted appropriately and within the scope of the applicable zoning and in related state laws in issuing the building permit. So that's a motion I suggest. Can I have a second?
I second it.
Seconded by Wadner. On the motion, Wadner Ajay.
Aye.
Steve Brooks.
Aye.
And the chair votes aye. It's a unanimous decision of the board to deny the appeal of the grant of the building permit. I want to thank everyone for participating tonight. Especially thank you to Jonathan Simpson, Susan Harris, for your joining us tonight, for your preparation for this hearing. And one more vote coming. We're actually going to vote to adjourn, which I will move. Is there a second?
Second.
Seconded by, sorry, who seconded? Steve, was that you?
Yes.
Thank you. On the motion to adjourn, Wadner.
Aye.
Steve.
Aye.
And Randolph votes aye. We are adjourned. Good night. Thanks to everyone.
Thank you. Good night.
Everyone.